acting CEO, had that opinion on the 10th of June 2016.
Yes.
And that is the opinion which refers to the fact that Sassa is not going to be able to meet the deadline.
Yes.
Thank you. Now, just to finish off, Minister, I have suggested to you that you deliberately concealed the truth about the full truth about the work streams from the Constitutional Court to avoid being held responsible for the crisis. You disagree with that?
Ngqongqoshe ngeke ngakubeka kuwe ukuthi wakwenza ngamabomu ukuthi ulugodle iqiniso ungalikhiphi lonke ngendaba yokwakhiwa kwama-work stream. Uyavuma lokho? Disagree.
And I have put to you, and I must put again, that you failed to report promptly to the Constitutional Court when it became clear that Sassa would not do what it had told the Constitutional Court it would do.
Ngiyaphinda futhi ngibeka kuwe ukuthi wehluleka ukuba ubabikele ngokusheshsha ehhovisi enkantolo yomthethosisekelo ukuthi Sassa ngeke ikwazi ukubamba umnqamulajuqu owawubekiwe.
You disagree with that?
Uyavuma noma uyakuphika?
Angivumi.
Disagree.
Yes. But the main part of the inquiry is, before the judge, is that I put that you concealed from the Constitutional Court the true nature of the work streams, and that this shows an attitude of disrespect to the court.
Ngiyakubeka futhi kuwe ukuthi awuzange ukukhanyisa ngokucacile enkantolo yomthethosisekelo ubunjalo bama-work stream futhi lokho kwaba ukungahloniphi inkantolo yomthethosisekelo.
You disagree with me?
Uyakuphika lokho?
Ngiyaphika.
I disagree.
And Minister, I unfortunately have to put to you that this is unfortunately not the only incident of disrespect on your part towards the courts.
Ngiyakubeka kuwe lokho ukuthi ngeshwa akusiso isumbe sokuqala lapho uye wabonisa ukungahloniphi inkantolo.
And I want to show a news clip of a statement which you made.
Ngizobonisa lapha i-clip nestatement owasenza.
The judge, we still must object. There is no relevance to whether or not there were similar occasions where the minister would have shown any disrespect to the court. It's not relevant to the issues before this inquiry.
Judge, the question before which the which the Constitutional Court has asked you to inquire into is whether the minister was in bad faith towards the court when she acted as she did in this case, which is a question of respect for the courts. And I submit that if she has been disrespectful towards the courts on other occasions, that's relevant to what is her attitude to the courts. It's the same person and it's the same issue. It's not even similar fact evidence. It's what is the attitude of the minister to the courts. And if she is generally disrespectful of the courts, that is a matter that is relevant to this inquiry.
Is it part of my brief to make an actual finding as to whether or not the minister acted in bad faith? Or is my brief simply to provide answers to the stipulated questions?
Well, the underlying question...
I don't recall that I've been asked to make this finding as to whether or not the minister acted in bad faith. That would have been a consideration for the purpose of determination as to whether or not she should pay costs out of her own pocket, an aspect which I don't have to resolve now. It falls exclusively within the terrain of the Constitutional Court.
Judge, that is with respect correct, except to this extent. One of the questions which you are asked to inquire into is why the minister didn't make full disclosure to the court. That goes to the question, you may find that she had a very good reason for not making full disclosure because it wasn't relevant, or you may find that it's because she was being disrespectful to the court. if she is a person who is generally disrespectful to courts, then it's relevant to the question why she didn't make a full disclosure to the court. Because you're asked to find what is the reason. If you discover that she's a person who's disrespectful to the courts, that will weigh with you in deciding why she didn't make disclosure in this case.
I don't want to open collateral issues, which are not going to be helpful to me towards answering the questions stipulated in the mandate. Are you inviting me to look into a previous conduct on the part of the witness?
Yes, Judge. The conduct disrespectful of courts.
And that alleged disrespect was in relation to which matter?
It was in relation, Judge, to the case in which the full bench of the Pretoria High Court set aside the appointment of Mr. Abrams as National Director of Public Prosecutions. The Minister made a public statement about that court, which was disrespectful.
I don't think that would fall within my province. I think it is, if the Constitutional Court wants to make that kind of finding as to whether or not she acted in bad faith, I think let it be done by the Constitutional Court, and then they'll decide whether they take into account. But for the purpose of this carefully circumscribed jurisdiction that has been conferred on me, I don't think I would like to go to investigate other matters. I really, Mr. Butler, decline your invitation to go into that.
In that case, I have no further questions for the witness.
Who's next? For freedom under the law.
Yes, Judge, that's me for freedom under law. But before we get going, it's occurred to us that, and perhaps it ought to have occurred to us earlier, and we should have raised it earlier, that had there been evidence leaders in these proceedings, the evidence leader would have put the versions of Mr. Dango and Mr. Magwaza to the Minister. As there are no evidence leaders, both the Minister and us are somewhat in the dark as to what Mr. Magwaza and Mr. Dango's versions are, beyond what is in the affidavits. And it's clear from the evidence of the Minister that we're going far beyond the affidavits. So we would like, firstly, to suggest that it's important that the versions be put to the Minister, and secondly, that the versions be put to the Minister now before we cross-examine her.
I'm unable to see why you wouldn't, on the basis of your own instructions and your own client's case, why you cannot cross-examine the Minister.
Judge, it's not a question of us being unable to cross-examine her. It's that we don't know what the other versions are. And as a matter of practicality, it makes sense for those versions to be put to the Minister before further cross-examination. If the reason why the Mr. Dango and Mr. Magwaza have representation, have been permitted to be represented in these proceedings, is partly because there is no evidence leader. And if
but they are going to play that role. One of my considerations
Yes.
was that there is no evidence leader, and therefore their counsel will lead them.
And if indeed there had been an evidence leader, the evidence leader would have consulted with Mr. Dango and with Mr. Magwaza and would have put to the Minister those versions to say this is what they are going to say. And it's our view that her responses to what is put to her is very important for us to determine how to handle the cross-examination.
You can't be dependent on what the witness's reaction would have been to the versions put to her by the evidence leader or Mr. Magwaza's counsel. I can't see why you would be dependent on that. Are you telling me that you want to await first to hear what version is being put to the minister of Mr. Magwaza's, and therefore the minister's response to that before you can cross-examine?
I am saying to you, Judge, that it would be preferable, so that we don't, simply because we don't know what they're going to say. There are some of,
why didn't you raise this issue before Mr. Butler started? You
to
are
be honest, Judge, it didn't occur to us before this morning, and I agree, we should have raised it before. I also think it would shorten proceedings, because on our questioning regarding certain things in the record which come from Mr. Magwaza and Mr. Dangle is somewhat in the dark, because we don't know what they're going to say. It will. I mean, we're not going to repeat anything if it's already dealt with. But I submit that it would actually, as a matter of practicality, streamline the proceedings somewhat.
There is no hard and fast rule to be applied here, because we have got some unusual situations here. And perhaps indirectly you are raising an issue as to whether or not Mr. Magwaza's and Mr. Dango's legal representatives are going to be asking questions to the witness.
I apologize, Judge. I intended to ask that directly as well.
Yes. And I don't know whether we really discussed that or debated that in full. Obviously, I've got certain provisional views about it, given the nature of their evidence. But now that that particular issue has arisen, I think it must be addressed. Not because there's a likelihood that I will necessarily yield to your request, because Mr. Butler has already, the first applicant, has already cross-examined and finished. And we cannot cut the procedure. We can't run the procedure in the form of cut and paste. You shall have to follow the path that has been followed by Mr. Butler. We cannot give you a different route. You would have to, just as Mr. Butler immediately went on with the cross-examination, so too would you have, I'm afraid. We cannot change the rules in the middle of the game. So that issue must be left alone. Let us therefore talk about the main issue, and which I've articulated, in which case I would then have to hear either Mr. Maleka first or Mr. Solomon first. But any one of them venturing into it?
Judge, with your leave, we would like to put certain questions to the Minister. The order in which it is done is within your province. But we do think, from our client's perspective, we needed to put his version and to put certain other questions to her, flowing from the differences in their versions that appear from. That's our standpoint.
Yes, I think two points. One, whether you would be entitled on behalf of your client to put questions to the minister, that's the one thing. If the answer to it is yes, then it raises the second point, that would be the ambit. Because obviously you're not going to run wild with the case. It must be, your exercise must be limited within the ambit of your client's implication. To the extent that you only put questions to the minister, to the extent that your client is implicated by the evidence, or by the minister's evidence. Bearing in mind, of course, that, and that's why I'm saying I'm limiting you, it is because your client is not a part of the proceedings. So you would have to limit, if the answer to the first question is positive, you have to limit yourself to the parameters that I've outlined. 1, 2, 3 questions may cause some debate about whether or not they are within the limit, but we can deal with that. Mr. Malik.
Judge, we will certainly take guidance from you, and let me make it immediately clear that my client as a witness does not assert a right to ask questions other than through your permission. But what has become clear from the testimony you have heard thus far is that my client's status in connection with the Department of Social Development has now been implicated beyond the ambit of the affidavits which have been presented before you. And that version which has now implicated him is the one that he disputes. And we would suggest that it is fair that his version on matters that he disputes in regard to the evidence which you have heard thus far should be put to the minister, subject to your guidance and control. And we think that if that rule of fairness were to be observed, your consideration of the evidence will be enriched, and you will be able to make a determination of which of the competing versions we should uphold in answering the questions put to you by the Constitutional Court. And to that extent, we would definitely ask for your leave to ask some questions without repeating the ground covered by Mr. Badlenda.
Yes. Mr. Semenya.
Judge, I think we need to be cautious because, and that caution dictates that we start looking at order number 3 of the Constitutional Court. That order reads, the referee will determine the most practicable manner for the conduct of the inquiry, which gives you the discretion, a judge. But it is subject to the following. The minister will commence with giving oral evidence and may thereafter, if so advised, call any other witnesses. So it is contemplated that the minister will be the first witness, and if so advised, may call any other witness. That's what the order says. Then B then reads, thereafter, the applicants, black sash in parentheses and freedom under the law, they identify which of those applicants they are. And remaining parties, which Mr. Dango and Mr. Magwaza are not, will be entitled to lead oral evidence if so advised. Then says in C, the amici curiae will not take part in the inquiry. So it is very strict about who would be entitled within your discretion under order number 3 would do what in these proceedings. And we submit if the rules of fairness are ever going to trigger your direction, a judge, then surely you would have been entitled to have obtained statements of these witnesses so that in our preparation of the ministers giving evidence here, we would have anticipated what other collateral issues would be raised. We would have canvassed that with her, and then she would have been ready in cross-examination to deal with them. We would think it very unfair in the middle of her evidence, after her evidence in chief, that she must confront in cross-examination issues about which there was no preparation with her.
I'm just trying to get page 2 of that order. Where is in my W1?
It is item 50 of the Black Sash judgment, Judge. Item 50 of the Black Sash bundle.
You may have to go back to argument. I've got the copy. I didn't have the copy at the time you spoke to me.
As we read, Judge, order number 3, it says the referee will determine the most practicable manner for the conduct of the inquiry, and we read that to mean there would be a discretion that you have as a referee judge. But that discretion, it says, as we read it, it is subject to the following. A, the minister will commence with giving oral evidence, i.e., we could not have had any witness other than the minister as the first witness. And may thereafter, if so advised, call on any other witnesses. So there is an opportunity for the minister, as we read this order, for her to call any other witness if she is so advised. And it is for that purpose that we prepared statements of 2 witnesses, which in our opening statement we said, in the event their evidence becomes necessary flowing from what the minister's evidence is, we may be minded with your permission to call them. Then says B, thereafter, the applicants, and in parentheses, they specify 2 entities, Black Sash and Freedom Under Law, and remaining parties will be entitled to lead oral evidence if so advised. And we make the point that the direction of the Constitutional Court, Mr. Magwaza and Mr. Dango are not such other parties at all. Then says it in paragraph C, the amici curiae will not take part in the inquiry. So it even excludes people who were participating before the Constitutional Court in the argument. It says in this section 38, they will not even participate at all. Now, if we hear the argument, they say there may very well be reasons of fairness that may justify you exercising a discretion in allowing certain questions to be put to the minister. We say, 1, that falls outside, Judge, with respect, outside of your discretion as we read the order. But we say, 2, even rules of fairness are putting us and placing the minister in a precarious position. It would be to deal under cross-examination with matters with which we did not canvass with her in consultation. It would be inviting her to deal with matters we did not canvass with her in examination in chief. It would be to deal in cross-examination with matters about which even us could never have anticipated because we don't know where they are. It would be to deal with matters about which Mr. Dango and Mr. Magwaza have not given us statements beyond the affidavits. So there's just a cumulative amount of factors why, in our respectful submission, Judge, it should not be allowed.
Mr. Semenya, I'll come to you, Mr. Mark. Mr. Semenya, obviously, 3A must be read together with D.
I concede that.
Yes. And now the only question now arising is whether under D, Mr. Dengo and Mr. Magwaza are entitled to put questions or cross-examine the minister. Isn't that the issue we are concerned with now?
Well, Judge, we're making the point that even on this, our reading of A and D of 3, Mr. Dango's evidence is not contemplated in this order at all. Neither is that of Mr. Magwaza. But we accepted that they would be represented, i.e. have legal representative who will, if they are so called by you, have their interest looked after by my learned colleagues.
Sorry. Why do you say Mr. Magwaza and Mr. Dango are not contemplated under D? How can that be so?
If we read the order, and Judge, you may rule us to be wrong in our reading. A deals with the evidence of the minister. She is being identified as the witness that will give evidence, and if so advised, call on any other witnesses. That's how we read it. B then deals with the applicants being black sash and freedom under the law, and remaining parties will be entitled to lead oral evidence if so advised. Mr. Magwaza and Mr. Dango are not parties in these proceedings. So it is not making any reference to them at all if you're reading this correctly. Then goes even further to say the amici will not take part in the inquiry. So it is not contemplating that Mr. Dango and Mr. Magwaza will become witnesses in these proceedings at all.
But, Mr. Seminyam, the reason, let me put it to you, had it not been for the affidavit by Mr. Magwaza and Mr. Dango, I might not exist. I might not be here.
I concede that.
Now, in light of the affidavits filed by Mr. Magwaza and Mr. Dango, in light thereof, bearing in mind that the Constitutional Court was confronted with affidavits, one on the one side by the minister and on the other side by the two gentlemen, the Constitutional Court was unable to answer certain questions, which in its wisdom could only be answered properly through oral evidence. Now, are you then suggesting that I must leave Mr. Magwaza and Mr. Dango out of account here in these proceedings?
No, I'm suggesting, a judge, that the judge has to take account of what they have said in their affidavits.
Yes.
And have the minister ask questions and cross-examined on the basis of the version appearing in the affidavits of those two witnesses.
Yes.
But it may very well be that you are inclined to have them give even viva voce evidence.
Two.
You may very well be inclined to have the viva voce evidence of Mr. Magwaza and Mr. Dango. We're saying in that event, surely fairness would have dictated that we obtain the statements beyond the utterances and versions that are put in the affidavits beforehand. And we're making the second point that in that event, we would have had an opportunity before cross-examination to have canvassed those issues with the witness in consultations and preparations for the hearing. And that's why we are trying to motivate why you may want to use your discretion not to go down that road. We would have had an opportunity to have canvassed all those issues with her in examination in chief. We would have had an opportunity to have had prior knowledge of the statements about which who would be tested. We haven't prepared it. I don't know what my learned colleagues have in mind as questions to be put to the witness. But those are the submissions that we're making.
Mr. Malika, my last recollection of proceedings would be that if the witnesses, or rather people have made affidavits, conflicting affidavits, and there's a genuine dispute of fact, the matter is referred to oral evidence. I would not have expected a summary of the evidence of the very same people who have made affidavits to be furnished to me prior to the hearing. I would expect them to do so only in respect of those witnesses who have not filed affidavits. You'll recall I commented in one of my directives that I'm becoming concerned about the ever-increasing volume of documents, and speaking with reference to the furnishing of copies of statements in advance. I indicated that I would have thought that the statements as to the evidence to be furnished would be only by those who had not yet made affidavits. And I don't understand if Mr. Magwaza and Mr. Dango are going to say nothing more, not one word beyond the affidavits they have filed. I can't understand what other statement they should have filed. Which is why I said that they will be subject to limitation if they are to cross-examine and or to testify. They would not be allowed to go beyond the parameters of the affidavits, which you have been having for years and years and years, and which you know, the contents of which you know. So it is of no bother to me that they have not served you with copies of statements in advance, as long as they are going to remain within the parameters of the affidavits which you have. But that is my understanding. But anyway, let me hear from Mr. Malek and then Mr. Solomon.
Judge, the submission of our learned friends ignore the very context of the basis of the reference by the Constitutional Court to you on why this inquiry should take place. May I, for the purposes of a short reply to those submissions, ask you to go to the Black Sash bundle and turn kindly to page 787.
Is it not here? Black Sash. They say Black Sash bundle. Yes.
Paragraph 18 on that page says the following about the status of Mr. Magwaza and Mr. Dango. And I ask you to read it together with me. Mr. Magwaza said that he called upon Mr. Dango to file an affidavit to assist the court in coming to a just and equitable decision. May I stop there for a moment? The fundamental basis of the affidavits, which both Mr. Magwaza and Mr. Dango made, were to assist the Constitutional Court to make a finding which is just and equitable. Because those affidavits raised a fundamental question of fact, which raised a serious dispute between the version of the minister as well as the version of Mr. Magwaza supported by Mr. Dango, the Constitutional Court could not come to a conclusion as to what version should prevail in order to make an order which is just and equitable. For the present purposes, that order which was just and equitable related to the question whether or not the minister should pay the costs in her personal capacity. It is quite clear by all accounts that there was no dispute of fact or version as between the primary parties in that litigation. There was no dispute of fact on papers as between Black Sash, supported by the other co-applicants, and Sassa and or the minister. The dispute of fact which prevented the Constitutional Court to make a finding which is just and equitable in relation to the liability to pay the costs in the personal capacity by the minister related to Mr. Magwaza and Mr. Dango on the one hand and the minister on the other hand. That's the fundamental context on which the Constitutional Court said it, given its processes, will not be able to resolve that dispute, but it will appoint a referee to inquire into that issue, make a finding on specific questions. So as we sit here, you are operating as a Constitutional Court on the ground to try and resolve that issue of fact. That is the context in which this inquiry has happened. Given that context, we would submit that in fairness, the parties to that dispute of fact ought to be given to explore the extent and the full parameters of that dispute without traversing matters outside the affidavits. The affidavits do not test the dispute of fact. They merely raise a dispute of fact. It is through a process of cross-examination, the greatest engine ever designed to discover the truth, that you will be able to test the versions of the parties relating to that dispute of fact. And given that legal device of cross-examination, we would respectfully suggest that it is fair that the version raised by the minister in the course of evidence today and yesterday about Mr. Dango that I represent should be explored in order to ultimately assist to make a finding on that issue, and thereby assist the Constitutional Court to make an order which is just and equitable on the question of costs.
Mr. Solomon, you have anything to add to that?
Thank you. Just briefly in response, Judge. I endorse what my learned friend, Mr. Maluleka, said. You are sitting, in a sense, to resolve what the Constitutional Court could not resolve without the hearing of oral evidence. Not to put too fine a point on the matter, if you look further down on page 787 of the judgment of Justice Froneman, you'll see at paragraph 20, these are serious allegations. If it is correct that the minister appointed the members of the work streams and that they reported directly to her in contravention of governance protocol, then her failure to disclose this to the court bears strongly on whether she has acted in good faith or not. For the moment, however, the allegations are untested. That raises the question, how must the affidavit evidence before us be approached in determining whether a personal cost order against the minister is justified? Now, it's quite clear that the two conflicting versions arise out of what Mr. Dango and my client, Mr. Magwaza, said, as opposed to what the minister said in her affidavit. Those are the two conflicting versions that have been placed really before you to resolve as an issue and to assist the Constitutional Court. You can't do that meaningfully without allowing the two protagonists, Mr. Dango and my client, to pose questions and to have their versions tested through a process of cross-examination with the minister. We also tend to agree with what you've said. One knows, if one has regard to the locus classicus on referrals to oral evidence, the metallurgical case, which has been followed since time immemorial, one would only require witness statements to be furnished to the opposing side and for the benefit of the court if those parties were not deponents originally, which caused the matter to be referred to the hearing of oral evidence. And we say by parity of reasoning, that's where we are here. We filed these affidavits. There was no necessity to file witness statements. The affidavits set out where the battle lines are drawn. It should have been apparent to all around this table where the battle lines are drawn. And we know, similar to a metallurgical referral to oral evidence, we have the terms of reference. We have the issues that you, Judge, have to resolve. And we know where the conflicts and disputes reside between the respective versions. So we would say we should be afforded the opportunity of putting our client's version and testing her contrary version where it differs from what my client has said under oath. Of course, it also impacts very gravely on his reputation. He is caught up in this collaterally in this fight. He has put forward a version as he sought as his civic duty to do so, which contradicts what the minister had done. And in you answering the 4 questions posed by the Constitutional Court, which you are charged to do on their behalf, there will be credibility findings can materially affect my client going forward. His reputation is as much at stake here as the minister's is. So he must be entitled to persuade you that his version is to be preferred over the minister. And the only way one can do that is through the tried and tested method of cross-examination. Thank you.
But that would also Am I denying somebody the opportunity to say something?
Yes, Judge. I sought with your permission to raise a very critical point. Judge, my learned colleague Maleka is right. And he's right when he says he cannot assert a right of his client to put questions. Witnesses do not have a right to cross-examine anybody in civil proceedings. He must be right. And the provisional view which, Judge, you took about the request that was in Mr. Magwaza's legal submissions to you was also correct. That I'm allowing you prayer one if it is a prayer, but don't read into it that I'm allowing the other things. These are witnesses. They cannot, in our law, assert a right of cross-examining any witness.
Is there somebody that I'm overlooking? Yes.
Just I'm sure it's already come through in what Mr. Maleka has said, but if there is no dispute of fact between the applicants and the minister, the only dispute of fact is between the witnesses and and the minister. So if the versions of the witnesses are not put to the minister, there's no real reason, or there's no basis on which this hearing can assist the Constitutional Court to determine that dispute of fact, because other than airing what the minister has to say, it can't test that version against anything else, and in fact against the very things which have raised the dispute. And for that reason, someone has to put those versions to the minister, and someone has to test her evidence as far as the dispute is concerned.
You can also put them.
Yes, Judge, but we don't have the dispute of fact, and we don't have the advantage of having consulted with the witnesses. They're not our witnesses.
No, you have the affidavits.
Well, Judge, if all that was going to be put to the minister was the content of their affidavits and nothing more, and if they were not to be able to respond, there would be no basis on which to even have them as witnesses in the.
No, I'm talking about you. You could put their versions to the minister.
I don't have their versions apart from what is actually in the affidavits.
Yes, you can put what is in the affidavit.
Yes, that is true. But
nothing prevents you from doing that.
No, Judge, nothing at all, except that I don't know anything beyond what is in the affidavits, and
maybe
the minister's
evidence.
The minister's evidence has gone beyond what is in the affidavits.
But you can put to the minister that which you know of.
Yes, I absolutely can. But we're not talking about what I can and can't do. We're talking about what how the minister's evidence can be tested beyond what is in the affidavits. And if all that was going to be done was for the minister to respond to what is in the affidavits without being further tested, all that had to be done was for the minister to file a replying affidavit, and then we could argue. But the matter has been referred to oral evidence for the testing, and as we know, the best method of testing evidence is through cross-examination and putting a version. And the people who have the version are not Freedom Under Law or Black Sash. People who have the version are Mr. Dango and Mr. Magwaza.
It can't be correct. I don't agree. I don't agree with you when you say to me you don't have Mr. Magwaza's version, you don't have Mr. Dango's version. I'm unable to understand that argument. I thought you have their version. That's what I thought. But let me just clarify this. Are we together that, because that's my position. My position is that Mr. Magwaza and Mr. Dango are going to go into the witness box. Are we clear about it? Is there anybody who is against that? Mr. Semenya?
With your directions, no, we won't object to it.
Yes, that's right. Now, I think we have resolved the matter to a great extent. Mr. Solomon and Mr. Malika, you agreed that all you do is with the minister is just to put your client's version to her. You don't cross-examine. Is that what you're saying? Because I understand Mr. Sminya to be understanding you as saying that. Am I wrong, Mr. Sminya?
We would resist them cross-examining. If they want to put their version, they're welcome.
Judge, can I ask for your guidance? And let me take an example where I have instructions.
Tell first what your submission is.
My submission is putting a version without the accompanying privilege of testing a competing version will be of no assistance to you. Let me give an example in the context of one issue which has arisen this morning when the minister was being cross-examined by our colleague representing Blacksash. It related to the role that Mr. Dango may or may not have played. And part of the answers that we gather from the evidence given by the minister is that she had appointed, I think the term she used was employed or deployed, Mr. Dango to represent him in several meetings and would have expected Mr. Dango to apprise and keep her up to date about the work of the work streams. Mr. Dango denies that version. We can, with your leave, put Mr. Dango's denial, but we would submit that it will not assist you in resolving the denial by Mr. Dango on the one hand and the minister's version on the other hand. On that issue, we would submit that it will assist you if we test the minister's version on that issue, because it harks back to the fundamental question on whether or not the minister had prior knowledge of the workings of the work stream, and whether by reason of having that knowledge, she ought to have disclosed the existence and the operation of the work stream to the Constitutional Court in her affidavit. And we would submit that on that issue alone, fairness would require us not only to put the version of Mr. Dango to the minister, but also to test her version against the denial by Mr. Dango. And that's a guidance we will seek from you, because what you will hear in that regard will help you to decide whether or not the version of the minister as against that of Mr. Dango is well-founded or not.
Judge, just to put our position, we would not limit ourselves simply to a mechanical exercise of putting a version contained in my client's affidavit and awaiting a response. The main purpose of cross-examination is to elicit facts from a witness or to impeach the credibility of the testifying witness, to lessen the weight of unfavorable testimony. Now, we can't do that simply by putting a version and just waiting blandly for a response and not being entitled to test the response, because the matrix in which the response operates and is given is what we need to test. You know better than any, with your more than 40 years experience, Judge, that probabilities come to play a very large role in determining credibility of witnesses. And the only way one can test probabilities is to put propositions that certainly fall outside a bland mechanical exercise of just putting to the minister what Mr. Magwaza has said in his affidavit. So we would not wish to limit ourselves to that. We are guided by you, Judge. We don't want this to become a lynch mob and ganging up against the minister. We've heard cross-examination that's taken place after the past number of hours by Mr. Budlander for Black Sash. We don't want to go and retraverse areas that he's traversed, but in order to test the version of the ministers against my client's version, one will inevitably have to look outside of simply putting a version and just look at the matrix under which these work streams were created, how my client fitted in, how the minister fitted in order to be of assistance to you in the Constitutional Court. Thank you, Chair.
Mr. Kasim, silence is gold.
I have two very short submissions.
Okay.
Firstly, Judge, you should take the approach what is practical at this stage. I think it's much more practical if you allow Mr. Maleka and Mr. Solomon to go. I think it will reduce Ms. Jacob's cross-examination considerably. I think that's a practical consideration. The second submission I want to make to you, Judge, you'll recall that the affidavits before the Constitutional Court were to this effect. The Black Sash and the other party were arguing that the minister caused the delay, and that's why the minister must pay from her own pocket and not the honorary principle that Sassa should pay. Then came two affidavits, which basically says the minister then puts an affidavit and she explains her position. And then comes the two affidavits and says, no, you're wrong. You did hijack this process. And that is really the issue before you. And on that limited issue, my learned friends are correct. Judge Coleman's judgment in metallurgical case says that you will allow cross-examination to determine the true facts. So with great respect, you can't limit what they're going to put. Otherwise, it's not a meaningful exercise. Otherwise, the court could have decided the matter on the papers. So just to come back, I think the practicalities are Mr. Maleka must start.
Mr. Hon?
Judge, we have no submissions. I can't add anything to what Casper said. I will be guided by your decision.
Any further submissions? Mr. Semenya, do you want to? Are you raising your hand?
Yes, Judge. Just to make 2 points arising out of what Mr. Kasim now says to you, which is something we haven't canvassed. Witnesses in our law don't cross-examine anybody. That's a matter of law, and nobody can contradict me on that, I'm sure. Secondly, Judge, practicalities can't go so far as to suggest that we had Mr. Budlander put all the versions that pertain to Mr. Dango correctly as a party, that pertain to Mr. Magwaza correctly as a party, and if the Constitutional Court was minded we go down that road, it would have joined Mr. Dango and Mr. Magwaza as parties to these proceedings. Then this debate would not be there at all.
Yes, everybody have had their say. Is it now left to me to consider the matter and make a ruling? Okay, I'm ready to make a ruling. There's one thing I'm not going to do. I am not going to allow, is Mrs. Who?
Judge? Ms. Yakub.
Yakub. I'm not going to defer your cross-examination for any reason. You will have to do what you have to. You are the second applicant, and Mr. Butland has just finished. It would be your turn. But before going further, let me say this. I have considered all the submissions made, and there is one thing that I am not keen to do, and that is to refrain from doing what I should have done and have the matter and tell myself I finished with the proceedings, submit a report to the Constitutional Court, and only for the Constitutional Court to find that I failed to do something which I should have done, because I would not expect, in the normal course of events, for the Constitutional Court to refer the matter back to me and say, well, we asked you to do this, we asked you to run these proceedings, but well and good, you did A, B, C, D, but you did not do E, D, and therefore we refer the matter back again, the matter to you back again to do D. If I were to be confronted with that kind of dilemma as to whether I should allow something in respect of which I would run the risk of not having allowed it, I would rather do something here, and if the Constitutional Court is not happy with what I've done, they can discard it and throw it out of the window. So I'm going to make sure that I've done all that I've got, that I must do, to make sure that I have not come short of my duties in relation to the Constitutional Court. That is the guiding principle to me. I would rather do more than what I should have done than do less than what I was expected to do. Now, having said that, I'm of the view that, yes, I heard what Mr. Semenya has said about witnesses not having a right to put questions to another witness. In my view, this is an unusual situation. In fact, the whole inquiry turns on the dispute which, as somebody has already correctly pointed out, is in fact between the minister and the two witnesses. There is no dispute of fact between the parties themselves. And that being the case, the minister having testified, in my view, in all fairness to Mr. Magwaza and Mr. Danko, they should have the right to cross-examine the minister in relation to those issues, particularly because they are going to come to testify and the minister is going to cross-examine them. So in all fairness, I'm going to allow them to cross-examine the minister. On condition that as and when they shall be so cross-examining the minister, they shall not repeat or cover the areas already fully canvassed and covered by the parties, the first applicant and the second applicant. And of course, needless to say, they will always be limited to within the province of their evidence as contained in their affidavits. They cannot go beyond that. So that being the case, if need be, I'll add further reasons to my ruling. But for now, I think I've sufficiently educated you about why I would like the procedure to go this way. Having said so then, finally, to sum up, Mr. Yakub, I do not grant your wish to defer your cross-examination until after certain versions would have been put by Mr. Magwaza and Mr. Dango. You shall proceed, and after you shall have finished, proceedings will go in accordance with what I've just articulated. So it is your turn.
Thank you, Judge. Judge, before I start, there's one other thing that I would like to clear up, and that is the status of the witness statements that have been filed by the Minister. The Minister has, and perhaps Mr. Semenya can clarify also, the Minister has referred quite substantially to the witness statement of Ms. Mvulane. And we're not sure as to what the status of that statement is in these proceedings.
Well, at the beginning, Mr. Semenya indicated that he might or might not call Mrs. Mvulani and or Mr. Metcalf. We know that extensive reference has been made to their statements. Not only reference, but to some extent reliance placed on them, on those statements by the minister in her answers to certain questions. I'll leave it to the good judgment of Mr. Semenya to decide whether he's going to find some way of validating those statements. Of course, if those unsigned statements remain that way, their status is not improved, any reliance so placed on them by the minister would fall by the wayside, because the minister would have relied on statements would not have been validated or properly gotten into the proceedings. That is how I understand it, but I don't know what Mr. Semenya decides to do with those affidavits. Sorry, not affidavits, those statements. And I think for your part, just proceed, unless Mr. Semenya wants to say something, which is not obliged to say, but if he wants to, he's welcome. My ruling is that you proceed to put questions in the same manner that Mr. Butland has been doing. Leave the difficulties of the weight to the statements by Mrs. Mvulani and Mr. Metcalf. Leave that to the Minister's Council, and in the end, to me.
Yes, Judge.
As to what weight to give to them if they are left with such an unclear status. Are you prepared to go on?
Yes, Judge.
Don't make me suspect that you are not ready. You keep on raising excuses.
No, Judge, I just wanted to clarify that, because at the beginning, before Mr. Badlender started, we did clarify that the minister's statement would be signed before the end of the proceedings, but nothing was said about Ms. Mvulane's and Mr. Metcalf's, and we assumed that that would be because they were not going to be relied upon. But it's now become apparent that the minister has relied upon them, and it would help to know to what extent the other parties should rely on what is contained in them, to the extent that there may be one or two paragraphs in them that the minister hasn't owned as her own evidence, or which she may not have her own personal knowledge of.
Well, if a difficulty arises in that regard, we'll deal with it.
Thank you, Judge. Good afternoon, Minister.
Good afternoon.
Minister, Mr. Butland has referred you to a letter at page 843 of the Black Sash bundle.
Umnumzana uBatlenda uye wathi ake ubheke incwadi esekhasini 843 yale bandlela le Black Sash.
Yep.
Yes.
You have it. Yes. And this is a letter from Ms. Lynette Mart, to Ms. Lynette Mart, on a Sassa letterhead from Ms. Mvulane.
Lena incwadi ebhalwe ngeletterhead yaseSassa evela kuMiss Lynette Mart eya kuMrs. Mvulane.
Yep.
Yes.
And this letter, in the first paragraph, says, this letter serves as a request to decline a request to present at a meeting scheduled to take place on the 26th of September 2016.
Yep.
Yes.
And that request to present at a meeting scheduled on the 26th of September if you'll turn to page 841 of the same bundle,
Yes.
you'll see that that is a letter from the Black Sash, dated the 12th of September 2016.
Yeah.
Yes.
And this letter is addressed to yourself.
Lencwadi ibhalelwe wena.
Yeah.
Yes.
And it's copied to Ms. Ramakopa, who was the CEO at the time,
Yes.
and to Mr. Dango, who was your special advisor,
Yeah.
and
Yes.
to Mr. Magwaza, who was the acting DG.
Yeah.
Yes.
And this letter requests that you, the minister, will appear at the meeting on the 26th of September, or to deliver a plan. Sorry, if you turn to page 842, where the request is, at the last paragraph of the letter, it says, civil society within the MTT thus formally requests the minister to intervene to ensure that the plan with clear timeframes is delivered by the next meeting of the MTT on 26 September 2016. You see that?
Yes.
So the MTT is the ministerial task team that you had set up. Yes. And they are requesting that you make sure that the plan is delivered to the MTT on 26 September. It's a request
Yes.
to you. Yes.
Yes.
And the response to that request comes from Ms. Mvulane in the letter on page 843. And she
Yes.
says that you can't do that. You can't present to them. Well, she says you can't present at a meeting. But it also means that you can't do what they ask in that letter.
Kuyiqiniso ukuthi yona lencwadi ke nakuba ichaziwe izathu zayo ukuthi kungani ongeze ukwazi ukuba lapho kuloko kusho ukuthi awusakwazi ukuyenza le nto abayicelile.
I think we should read the asifunde yonke incwadi.
Let us read the whole letter.
Okay. Minister, do you want to read the letter?
Mhlambe singacela uyifunde.
Or which do respect and regards this letter serves as a request to decline a request to present at a meeting scheduled to take place on 26 September 2016. Please be informed that the ministerial work streams were appointed and started on the 28th 7/16, effectively now 8 weeks on the job. The first draft document in relation to multiple innovative models is near completion and not yet ready, as a number of due processes have to be followed, including verification of facts and alignment with key Sassa stakeholders, especially with regards to the grant chart developed.
Are you done with that letter? That part?
Yes, I'm done with the letter because it gives the explanation of the processes. But also, the reason the MTT was established it had a different terms of reference. Angifuni ukukhuluma ngokunye.
I don't want to talk about something else.
Angazi kwagcina kanjani sekungena la kulezinto ezibalwayo la ngoba ama terms of reference aye clear kakhulu.
Because the terms of reference were clear. I do not quite understand how the letter ended up mentioning the things mentioned in it.
I'm sorry, Mr. Interpreter, I didn't get that last part of what you said.
Okay, may I just repeat then?
Yes, please.
I do not quite know how the things that are now mentioned here ended up in the letter because the terms of reference were clear.
Sorry, Minister, you don't know how the things that Ms. Mvulane put in the letter, which you now read out, ended up in the letter. Is that what you're saying?
Ingabe yiko indloko othi lezinto ezibhalwe la awazi ukuthi zangena kanjani ingabe yiloko kushoyo.
Ngithi kumele sibheke emuva ukuthi yaqala kanjani i-ministerial task team.
Well, what I'm actually saying here is we need to look at why or how the ministerial task team came about.
And okwesibili kufike kanjani ukuze ukuthi i-black sash ishiye esahlangene ngako eqaleni ibise iyongena kokunye ngaphansi kwegama le-ministerial task team.
And also it would be good to know why Black Sash moved away from what we had initially met about and started talking about other things.
Well, Minister, perhaps your counsel will deal with that in your re-examination. I can't answer for that, but for now, you've accepted that this letter was the response from Ms. Mvulane to this letter from the Black Sash that was addressed to you.
Noko uyavuma ukuthi lena kwaba incwadi eyimpendulo kaMs Mvulane encwadini eyayibhalwe iBlack Sash ibhalelwe wena.
Okay.
Okay.
And then if you can turn to page 842 again. The third paragraph from the top. It says, Sassa has also not met many of the deadlines provided to the Constitutional Court. Civil society within the MTT is concerned that there is now a real risk in them not being able to insource payments by the end of March 2017. Without a clear sight of a new payment system, including a protected bank account being in place, social grant beneficiaries will continue to be vulnerable to deduction in debit order abuses and other violations. It seems as if Net1 and its subsidiaries and other financial service providers are getting away with impunity. You see that?
Yes, I can see it.
Minister, this letter was addressed to you. Do you read all the letters that are addressed to you?
Yes, reading I do.
Yes, and you saw this letter in September 2016.
Wayibona nale ncwadi.
Ngiyakhumbula sikhuluma nozodwa ukuthi i-MTT ifuna ukungena emsebenzini wakasasa.
I remember Zodwa and I talking about the view that was becoming apparent, namely that MTT wanted now to begin to do some of the work that Sassa should have been doing.
Ngichazile ekuqaleni ukuthi i-MTT yayikade yakhelwe okunye. Kodwa kuyangidida ukuthi yayisingena kanjani kulezi ndaba. Sakhuluma lokho nozodwa.
Yes, I remember Zodwa and I discussing this. It really was a concern that MTT was beginning now to infiltrate the turf of Sassa.
Thank you, Minister. If I can ask you to turn to page 287 of the Black Sash bundle.
Page
287.
287.
Mister, this isn't. Oh, you don't have it yet. Sorry. Do you have it?
Yep.
Yes.
This is an email from Mr. Dangle.
Then I email. Yes.
And it's dated the 25th of January, 2017.
Ngiyayibona.
Yes, I can see it.
Yes. And this letter is to give you an update, this email,
Yep.
because you were not there.
Yep.
Where were you on the 25th of January 2017? Were you in Addis?
Wawuphi ngalolu suku lomhla 25 January ngonyaka odlule?
Angisakhumbuli.
Also Addis.
Angisakhumbuli.
I do not remember.
You do not remember. He says, I hope all is going well in Addis. So we assume that you were at the conference in Addis at the time. But that's not relevant in any event. Do you remember receiving this email?
Yes.
Yes. And you'll see that he refers firstly to the government technical team in the first paragraph, with National Treasury and the Reserve Bank also getting involved.
Yep.
Yes.
And then that they made the decision about extending the existing contract with CPS. Yes.
Yes.
And then if you go over the page, he talks about how it's important to, in the second paragraph, it's important to ensure the continued support and partnership of National Treasury and the Reserve Bank. You see that?
Yep.
And he says
Yes,
that
I can see it.
thank you, this partnership is based on the firm plan that he's outlined above and continued government technical task team being led by Sassa.
Yep.
Yes.
Yes.
Then in the next paragraph, and the second sentence, he says, I had to work hard to persuade the Reserve Bank and National Treasury to continue their support when it emerged that Sassa had provided Minister with briefing notes for a discussion with the Minister of Finance that was quite hostile to the idea of using the national payment system and the open architecture model. Despite the work that was being done by the technical team comprising senior staff of the National Treasury, Reserve Bank, Department of Social Development, and Sassa. Yes, and then he says we could not use the kind of arguments used by the Sassa work streams that compiled the briefing notes. You see that? Yes.
Yes.
So he's, and then the next sentence, that National Treasury impressed on all of us, particularly Sassa, to ensure that the only document that was produced for consideration by the Minister is the one that was worked on by the technical team and as agreed by all four institutions today. Yes.
Yes.
And then he says there is a sense that at times parallel documents prepared by the work streams were being produced and that this was not helpful. You see that? And
Yes.
Minister, you read this email when it came to you, didn't you?
Why
Yeah,
phone?
my phone.
Yes, I did read it.
Yes, you did. And so you knew on the 25th of January that there was a sense that there were parallel documents prepared by the work streams and that this was not helpful. That there was a sense that this was not helpful.
Nginenkinga futhi ngale ncwadi
I have a problem with this letter.
ngoba i-document engangiyisebenzisa yayingafikanga ivela kuma-work stream yayiphuma kaSassa.
Because the document that I was working with did not come from the work streams. It came from Sassa.
Okwesibili, le process okwasekukhulunywa ngayo la kwakhulunywa nge-short term process yokuresponda ngomhla ka-1 ku-April ngoba kwakubonakala ukuthi kunenkinga.
And the core subject here was about something, about how to address the question of 1st April 2017, the deadline.
Yeah.
That was now, it was a short-term arrangement of how to address the deadline that was imminent.
And before uthathe isinqumo noma uzosebenzisa yiphi i-model faneke uyi-understand ukuthi izoba nama repercussions athini kulaba abahola i-grant.
Before you take up any model, before you decide to use any model, you really need to interrogate it, understand it, what repercussions it may come with as regards those that it will affect.
So akuyona open architecture kuphela eyayikade ikhulunywa ngayo la. Kwakhulunywa nge-open architecture, kukhulunywa nge-post office, kukhulunywa ngokuthi wonke umuntu ohola i-grant asimhambise ayoyibhalisa e-bank.
Okay. This open architecture model was not the only option. There were others. Among them, the post office, and there was also the thinking that everyone that needed to draw a grant needed to go to be registered. What?
Go and
Enrolled.
get enrolled in the bank.
Okay. Open a bank account.
Yes.
Is that it? Okay.
Logo esasikubiza ngokuthi i-hybrid model.
We used to call that a hybrid model.
Akaze kwaba nesikhathi la kuba nenhlobo eyodwa yokukhokha i-grant. Iba i-hybrid and iya ngokuthi abahola i-grant bazoyihola kanjani.
There's never been a time where there was only one way of paying this grant, because it depends also on how people prefer to draw the grants.
Since we started with this process.
Since we started with this process.
Okay, and then
I was just repeating for the lady.
number 2, I think kune meeting ka 5 October 2016 eyayise St. George's.
There was a meeting at St. George's.
Get those minutes up, please. Get those minutes up. Minister, we'll get to that meeting in a moment.
Sisazoya lapho.
May I interrupt you?
Ngicela ukukuphazamisa okwamanje.
Ngicabanga ukuthi kumele ngiphendule umbuzo ubuziwe.
I think I have to respond because a question was asked.
Okay,
Okay, you can proceed.
Sorry, Minister, you're not continuing.
Go ahead.
Okay, sorry, Minister. Just for now, the question is that on 25 January 2016, Mr. Dango raised with you, whether his perception was correct or not, but he raised with you that there was a sense that parallel documents were prepared by the work streams being produced, and that this was not helpful. 2017, yes.
January 25 January 2017.
Okay. Mingaki imhlangano eya attendwa Mr. Dango ephathelene neindaba zakaSassa.
It would be good to know how many meetings were attended by Mr. Dango relating to the business of Sassa.
I'm sure that will be part of the examination of Mr. Dango, Minister, but for now it's just he brought this to your attention. Or he mentioned it to you.
Proceed to the next question.
Yes, Judge. Did you respond to this email, Minister?
I'm not sure.
You're not sure, okay. Where's the Minister? If I can ask you to go to page 298 of the Minister's original bundle. Are you there, Minister?
Yep.
It's page. This is now the minutes of the meeting on the 5th of October, 2016. Yes, and this is the meeting that you were referring to earlier. Yes, and
Yes.
it was attended. If you look at the attendance register, by yourself and Ms. Mbulane and the leaders of the work streams. Is that correct?
Yes.
And there were no one from Sassa was in attendance at that meeting.
Sorry, no what?
No one from Sassa, apart from Ms. Mbulane, was in attendance at that meeting.
Kulo mhlangano akekho osebenza eSassa owayekhona ngaphandle kaMs Mbulane.
Inkinga yale register ayisayinwanga.
There's a problem with the register, it is unsigned.
Kuphinde kube nama comments akhona lana
And there are
ongawa
also,
understand noma ama comments ayenziwa abantu ababese meetingini.
and then also there are comments here made. One is not sure whether it was by people that were at the meeting or not.
Yes, Minister, that is, Mr. Dango is reflected as having made comments, and he's not listed on the attendance register. And Mr. Ramakoba is listed on page 300, but she's not in the attendance register. That's what you're referring to.
I beg your pardon?
Is that what you're referring to?
Usho
Yes,
abantu
yes.
abanjengo.
And do you
Yes.
remember whether they were at that meeting?
Angikhumbuli kodwa ama-comment ala abonisa ukuthi babe khona noma benza i-feedback.
I do not remember for sure, but the comments as they stand seem to indicate that they were present or they were responding or they gave their views later.
Okay. And Minister, the minute starts with what is called Minister Meeting Feedback 1, and at the subheading of that is Minister Feedback. And this was feedback to the work streams from the Minister of what was required. Is that correct?
Mm-hmm.
Yes.
And in that part of the meeting, there was no mention of 31st March 2017. That first part of the meeting.
No.
No. Then we have Minister Meeting Feedback 2, and that has got 4 sections. It's got Zane comments, and then Minister Feedback, and after that Rapathle comments and Minister Feedback. You see that?
Yes.
And this was Mr. Dango commenting and then being responded to from your side, and Ms. Ramakopa being commenting and being responded to from your side. Is that a correct reading of these minutes?
Mm-hmm.
Yes. And under Zane comments, you'll see it says approach should start with April 2017. Expectation versus reality. And then it mentions a number of options. And the response there, Minister Feedback, says that there's no time for options. Start with low-hanging fruit, government cutting budgets in all departments. You see that?
Yes.
And that, secondly, that it was urgent to meet with political advisory.
Yes.
Yes. Who is political advisory?
It was an interface committee that I had put in place so that there could be a center that would receive reports from the work streams and Sassa.
Yes. And Minister, this was your response to call this urgent meeting to Mr. Dango, raising the question of April 2017, yes?
Yes.
Yes. And then we look at the remainder of the minutes. Workstream wrap-up 1 and workstream wrap-up 2, which appear on 301. And that's the end of the minutes.
Yes.
And these are the reports from the work streams.
I think it's too compressed report of the work streams.
It is very compressed and it's difficult to read, but is that what they're supposed to be, the reports of the work streams?
No, work streams presented a full written report. So this, I think this was for the purpose of the meeting.
All right. And in this part of the minutes, there's nothing coming from the work streams which says anything about April 2017.
Angikuboni log.
I cannot see it.
Okay, thank you.
Inkinga yalama minute awabhaliwe ngendlela ukuthi unganeliseka ukuthi zonke izinto zibhaliwe kahle.
The problem with these minutes is only just a handful of things is mentioned, but there are other things that have been left out.
All right, Minister. So the minutes, you say they leave a lot out, but let's go back to page 301. You see the second bullet point under workstream wrap up 1.
Yes.
It's got in capital letters, it says risk, and then it says 2 to 3 year transition period, slipped down to 2 years during discussions, and Minister has then asked for it to happen even sooner, perhaps 2.5 years with full cooperation and compliance from Sassa. You see that?
Yes.
Yes. So this means that the transition period was expected to be 2 years. Is that right?
Which one?
The second bullet point.
Transition.
Yes, transition period slipped down to 2 years.
Yes.
Yes. And it also says Minister has asked for it to happen even sooner.
Yes.
Yes. But then it says perhaps 2.5 years with full cooperation and compliance from Sassa.
Yes.
Yes. Do you recollect, is this a correct reflection of the discussion about the transition period?
Yeah, ngiyakukhumbula lokho. Kodwa ngiyakhumbula futhi kukhona isikhathi la esehla sathi maybe asiye phansi ku-18 months. Kodwa akukho lana.
Yes, I do remember that, but I also remember that we contemplated the possibility of making it 18 months,
18.
although it's not reflected here.
18 months, thank you. And this was in October 2016?
Yes.
Yes. Okay. It's here. It's in the black sash bundle. No, not that one. Yeah, not that one, the other one. I'm sorry, Judge, I just need to find something quickly. His application.
Mr. Cook, if this would be convenient for us to adjourn, unless somebody has an objection, I would rather we adjourn now instead of you starting something else, moving on to something
Yes, Judge,
else.
I am starting something new. So.
Yeah. I think this must be a convenient point then to adjourn until tomorrow at 9 o'clock, please.
So
Thank you, ladies and gentlemen.
So yes, I went. You.